The totally not corrupt Judge Juan Marchand, whose daughter is totally not working at a PR firm that is making millions of dollars, hands over fist based on the Trump prosecution, who's totally not working with Adam Schiff, who is raking in millions of dollars in donations based on the Trump prosecution. He totally did not just issue the most ridiculous, motivated reasoning judgment against Donald Trump's contempt orders today. Viva Frei, former Montreal litigator turned current Florida rumbler, and yeah, I'm going to remind everybody out there that Judge Juan Marchand's daughter is an executive at a PR firm that works with Adam Schiff. Democrat political action committees worked with the Kamala Harris 2020 campaign. She did a podcast in 2019 where she spoke about how her father told her how he hates politicians that use Twitter, referencing Trump specifically. Yeah, that judge who gagged Donald Trump just issued a contempt order against Donald Trump on 9 of the 10 charges of contempt that were brought against him. The decision is pure motivated reasoning. You knew where the judge wanted to go before he even started drafting this. I suspect he drafted this a long time ago, and I've got hard evidence, I think, to suggest why, but we're going to get into this ridiculous decision right now. Supreme Court of the State of New York, County of New York, Part 59, the people of the State of New York against Donald J. Trump, defendant. Juan M. Marchand, AJSC, background. Defendant is charged with 34 counts of falsifying business records in the first degree in violation of Penal Law, Section 175.10. The charges arise from allegations that defendant attempted to conceal an illegal scheme to influence the 2016 presidential election. Specifically, the people claim that defendant directed an attorney who worked for his company to pay $130,000 to an adult film actress shortly before the election to prevent her from publicizing an alleged sexual encounter with defendant. It is further alleged that defendant thereafter reimbursed the attorney for the payments through a series of checks and caused business records associated with the payments to be falsified to conceal his criminal conduct. Trial on this matter commenced on April 15, 2024. I just read so much steaming judicial bullshit. My eyes are turning brown. Holy crab apples. Can you believe that framing? Can you believe this is the judge sitting on the trial describing this case like that? This case is a bona fide lawfare persecution against Donald Trump. It is a bogus case that even previous attorneys decided not to take up. It's such a bogus case that the feds looked into this and found no violation of federal election law, but New York finally found their useful idiot in Alvin Bragg, Soros-funded Alvin Bragg, to bring these bogus charges, and they found a judge sufficiently corrupt to not dismiss this outright, that being Judge Juan Marchand, whose daughter, did I mention, works for a PR firm that's representing Adam Schiff, political action committees for the Democrats, and worked with Kamala Harris. Oh, did I mention that yet? Did I mention that his daughter's making millions of dollars and the people she represents are making millions of dollars in donations based on this prosecution? Did I mention that? Because the judge is punishing Trump for bringing that to the attention of the general public. Not going to go over the procedural background in any meaningful detail. I've done vlog after vlog about it. The judge issued a gag order, then issued an expanded gag order because he forgot that he didn't include his daughter, his family members in that initial gag order. So he issued an extended gag order that bars Trump from talking about anything that might target potential witnesses, that might target family members of the court, of the judge, of the district attorney. In other words, in addition to bogging Donald Trump down in a 6-week trial in a 2024 election cycle, bogging down the leading candidate in 6 weeks of bogus trial, the judge also gagged that defendant's constitutional right of free speech, gagged that defendant so that he can't even talk about this case. He can't talk about certain things that are necessarily, definitely political in nature because of this gag order, and the judge today just found him guilty on 9 of the 10 charges of violating that extended gag order. And if that doesn't make you mad just listening to me describe what's going on, I want whatever you're on, except if it's blissful ignorance, because even blissful ignorance is not going to save society from what is coming if this crap continues. People are going to lose faith in the judicial system. This is how a society crumbles and falls into the realm of kangaroo court, banana republic regimes that nobody has any faith in and that destroys the very fabric of a free society. So the totally not corrupt Judge Juan Marchand, whose daughter is totally not making millions off the prosecution of this case, he issues the gag order. Donald Trump says, "Phooey to your gag order." I'm going to respond to some of the comments that some of these potential witnesses are making against me on Twitter. I'm going to raise facts to the general public. I'm going to retweet or requote, paraphrase journalists. I'm going to do that because you're not shutting me up. You're not gagging me. You're not violating my First Amendment rights. And the judge says, yes, I am. Trump was brought up on contempt charges for 10 specific things, 10 specific publications, 2 things that were published on his website, and 8 Truth Social posts. I'm going to go through them because you need to see how absolutely absurd it is what Trump was brought up for on contempt and what the judge just found him guilty for on contempt. A Truth Social post on April 10, 2024 at 10:07. Thank you to Michael Avenatti for revealing the truth about 2 sleazebags who have, with their lies and misrepresentations, cost our country dearly. That Truth Social post was indeed in respect of two sleazebags, one being a lying porn star and the other being a convicted perjurer, according to Justice Engeron Michael Cohen. From April 10, 2024 at 10:48 a.m. Look what I just found. Will the fake news report it? And as you can see, it's a letter from Stormy Daniels confirming that on 5 separate occasions, she affirmed that she did not have a sexual relationship with Donald Trump and that she was confirming this not because she's under NDA, but because the relationship never happened. Will the fake news report on it? Hell no. And the fake courts are going to sanction you for bringing that fact to the attention of the general public. Here we've got one linking to an article in the New York Post. And here's one from April 17, 2024 at 5:46 p.m. Quote, they are catching undercover liberal activists lying to the judge in order to get on the Trump jury, end quote, Jesse Waters. I didn't read all of them, but those are the best of the best. The 9 posts for which Trump was just found guilty of contempt, some of them were posting a link to an article in the New York Post. I kid you not. And when I say that this decision is pure motivated reasoning, the judge wanted to come to certain conclusions of law. He was going to come there regardless, and this is how he does it. And by the way, I should say that the 9 charges of contempt for which Trump was found guilty, the judge imposed a fine of $1,000 per charge. The judge wants to lock Donald Trump up so badly, you just know that he's biting at the bit to do it. But for now, he's got to start with financial repercussions, then he's going to move to jailing Trump. I have no doubt about it. Actually, I do have some doubt about it, but the thing is, they've been crossing one Rubicon after another, not with impunity, but with reckless disregard for the consequences to the social fabric of America. I have no doubt the judge wants to jail Trump and is going to look for any excuse to do it after imposing this financial penalty. Decision. The court rejects defendant's arguments and finds that the people have established the elements of criminal contempt beyond a reasonable doubt as to exhibits 2 through 10. This court's expanded order is lawful and unambiguous. Can you imagine the judge who issued the expanded order declaring his own expanded order, his own expanded gag order, First Amendment rights be damned, he's declaring his own order lawful and unambiguous. Defendant violated the order by making social media posts about known witnesses pertaining to their participation in this criminal proceeding and by making public statements about jurors in this criminal proceeding. The judge then gets into Trump's argument that he was merely reposting, he wasn't making the statements himself, to which the judge says, nah, we're going to do it on a case-by-case basis, and in this situation, it's clear that when you reposted them, you were making the statements yourselves. You were taking those words from that New York Post article, and you repeated them as if they were your own words, your own thought. You made them your own by retweeting, by retruthing, by reposting that New York Post article. And when it comes to the quote by Jesse Waters, the judge says, well, you sort of paraphrased, you changed the wording a little bit, you put it on blast, you made Jesse Waters' statement your own, and therefore you attacked the jury. You suggested activists were lying to get onto the jury. You made those words your own. You made the statement, therefore you are in contempt of my court order. Thus, there can be no doubt whatsoever that defendant's intent and purpose when reposting is to communicate to his audience that he endorses and adopts the posted statement as his own. I hope all you frothing at the mouth, smooth-brained idiots out there who are cheering on this judge right now for sticking it to Trump appreciate what the judge just said there. If you repost something, anybody can decide that you affirm, make your own, and approve of those statements. You endorse those statements. Of course, you're just going to have to rely on the judge not to go after his political allies, but only to use this rationale against his political adversaries. It is counterintuitive and indeed absurd to read the expanded order to not prescribe statements that defendant intentionally selected and published to maximize exposure. This is not to say that a repost will always be deemed a statement of the reposter, as context is directly relevant. However, here, under the unique facts and circumstances of this case, the only credible finding is that the reposts constitute statements of the defendant. And I will steelman it and say, even if I agree with you, so the hell what? You think as a judge you get to gag a defendant from sharing a link to a New York Post article? You think you get to gag a defendant to say out there that he thinks there might be problems with the jury in a wildly politically biased jurisdiction? You think you get to gag a defendant while 2 of these star witnesses get to run their mouths 24 hours a day, 7 days a week on social media? Oh, but don't worry. He carves out an exception for the Michael Cohen and the Stormy Daniels, who are doing podcasts, who are shitposting against Trump in real time. He says stop doing it on a going forward basis and we won't have a problem, but if you do it on a going forward basis, I might have to factor that in. But for the stuff of the past to which Trump was responding, you get a pass, Trump, you're in contempt. It is of the utmost importance to this court that the expanded order not be used as a sword instead of a shield by potential witnesses. Consideration of such usage will be weighed by this court when ruling on the willfulness of any future claims of alleged violation of the expanded order, as well as when determining appropriate punishment, if any. In fact, the court may very well consider the propriety of continuing the limitation on extrajudicial speech as it relates applies to certain individuals. As this court observed in the expanded order, quote, it remains the court's fundamental responsibility to protect the integrity of the criminal process and to control disruptive influences in the courtroom, end quote. Understand exactly what is going on here. Trump, I presume, argued that, look, all I'm doing is responding to the shit posting from Michael Cohen on Twitter. Michael Cohen posts a tweet with Donald Trump's plane with a Denver boot making jokes about Donald Trump's bond in the other court case. Michael Cohen called Donald Trump Mr. Shittin' Pants or something along those lines. They have both, Michael Cohen and Stormy Daniels, been needling, mocking, and trolling Trump on social media, and when he responds, he gets in trouble for it? It's almost by design. But the judge comes in here and says in his judgment, well, now I'm going to consider this going forward. If some of the witnesses are using this gag order as a sword and not a shield, I'll factor that into any future considerations of contempt and any punishment. But what's really funny about this, for anyone who's been paying attention, 5 days ago, Michael Cohen put out a rather bizarre tweet. Michael Cohen, at Michael Cohen 212, despite not being the gagged defendant, out of respect for Judge Marchand and the prosecutors, I will cease posting anything about Donald on my X, formerly Twitter account, and on the Mea Culpa podcast until after my trial testimony. See you all in a month or more. Hashtag Team Cohen. And look at that face. My goodness, who the hell would want to be on that team? So 5 days ago, Michael Cohen comes out and says, look, I'm going to stop posting on Twitter out of respect to the judge until after my testimony. And 5 days later, the judge somehow magically, mysteriously, and judicially finds a way of responding to Trump's argument that I was only responding to Michael Cohen's tweets. Holy cows, it's almost like people are talking behind the scenes. I don't know that they are. I don't know that they're not. All that I know is that 5 days ago, Michael Cohen comes out and says, I'm going to stop tweeting. And in this decision, it says, if the witnesses stop tweeting, then I won't consider it going forward. That if the witnesses stop tweeting, it will resolve at least one of the arguments of Donald Trump, and it will avoid an obvious, painful, and glaring issue with this gag order, that the purported protected witnesses were free to run their mouths while Donald Trump was gagged and now found in contempt for responding to that witness trolling. Oh yeah, and the judge also said that it was not political speech that Trump was issuing out there. It was witness intimidation, interference, etc. It's a load of motivated reasoning bullcrap. Judge Marchand then goes on to explain the $1,000 fine per infraction, but says, yeah, it might not be enough and jail might be necessary. While $1,000 may suffice in most instances to protect the dignity of the judicial system, to compel respect for its mandates, and to punish the offender for disobeying a court order, it unfortunately will not achieve the desired result in those instances where the contemner can easily afford such a fine. In those circumstances, it would be preferable if the court could impose a fine more commensurate with the wealth of the contemner. In some cases, that might be a $2,500 fine. In other cases, it might be a fine of $150,000. Because this court is not cloaked with such discretion, it must therefore consider whether in some instances jail may be a necessary punishment. Therefore, the defendant is hereby warned that the court will not tolerate continued willful violations of its lawful orders, and that if necessary and appropriate under the circumstances, it will impose an incarceratory punishment, and it is hereby ordered that defendant pay $1,000 fine for each of the 9 violations of this court's lawful order by close of business on Friday, May 3rd, 2024. And it is further ordered that the defendant remove the 7 offending posts from defendant's Truth Social account and the 2 offending posts from his campaign website by 2:15 p.m. Tuesday, April 30, 2024. The foregoing constitutes the decision and order of the court. Judge M. Marchand, whose daughter totally works for a PR firm that is representing Adam Schiff and making money, millions of dollars, hands over fist, as a direct result of this prosecution over which her father is the sitting judge. So that's it. It's a steaming pile of judicial dog poop. And if you think you like this steaming pile of judicial dog poop just because it's directed at Trump, one day you will wake up and you'll be standing knee deep in this pile of judicial dog poop, because it doesn't end at Trump. It starts at Trump, and then it takes away all of our rights. But at least now you know, and if you like what I do, take 1 second to go smash that subscribe button, drop a comment in the comment section below, share this away. More important than anything, get out there, sunlight, exercise, eat healthy, talk to people in real life, and now you know you vlog. Peace out, peeps. Booyah!
I had one last thing to say about tools. A lot of what I do involves motions. These summary judgment motions I mentioned. And all right, am I following the law or am I making law? Okay, I'm following law. I'm an impartial referee, but it's hard to factor out my own emotions. And I have tools. Somebody can say, well, Your Honor, you have to throw out this case because it's just like another case. Well, is it just like another case? What if the defendant was wearing a red sweater instead of a blue sweater? Well, that's an extreme example. That wouldn't distinguish most cases, but there are other facts that do. Maybe the education of somebody who supposedly entered into a contract would decide whether the contract was binding. I have a tool that I'll call a tool called estoppel. somebody makes an argument and I say, you can't make that argument. You made a different argument 3 months ago in this case, or even in another case. So I wish you all luck. I'll stand here or around afterwards for questions. And again, thanks to the administration for having me.